Chille's filing a lawsuit against Judge Zimmerman, Judge Leavitt, the prosecutor, Agnes, Officer Bork again, and he's also naming the guy with the beard who was the marshal in Judge Zimmerman's courtroom. He also mentioned that there were going to be a defamation claim attached to this. It sounds like he's going to be suing a publication that ran stories about him he did not like. And it even sounds like he might be suing some YouTubers because he says they defamed him. Well, since I live in the world of defamation, they usually don't get to trial because I usually win the case on anti-slap grounds anyway.
Adam, I'm about to sue this judge, man. I'm about to sue this judge. Tomorrow I'll be hardcore on the fundraising part of it.
That'll be today.
Today is just a precursor for Team DLZ. They'll go by there, drop $5 or $10 in, but I'm going to sue this judge. So let me read this to you guys. There.
Now I will hand it to Chille. Anybody that would have a complaint on their laptop in their car while they're looking to get something to eat is committed to the cause.
It is. So this is the federal, I guess, month or so. This says complaint for damages. Who am I suing?
By the way, it's blurry for me too.
Suing Clark County, Nevada. They're being sued. Suing Judge Ann E. Zimmerman in her individual capacity. Suing Judge Michelle Leavitt in her individual capacity.
That was a surprise.
Suing Agnes Botholo, Deputy District Attorney in her individual capacity. Suing Brendan Bork, Officer LVMPD in his individual capacity. Suing bailiffs John Doe in his individual capacity. And
I thought that Judge Zimmerman referred to the man with the beard as a marshal as opposed to a bailiff, but it may not really matter because what matters is the name. In California, you sue in fictitious names when you don't really know the name, but this wouldn't be very hard to find. So if I were Chille, I would just put the guy's name in there.
May be a defamation claim. I'm not sure if you guys can see this very well, but there may be a defamation claim that I'm going to be filing as well.
Now that could be against the local, there was a newspaper or a magazine. I don't really know. I haven't looked into it. He mentions who it is, and he says they ran articles about him. Of course, by saying that they ran articles about him, he is automatically moving straight into anti-slap territory.
Including 2 front-page stories.
What this also means is that it's newsworthy. And when it's newsworthy, you get into public interest. And when you get into public interest, you get straight back into anti-slap territory again.
Clark County's silence in the face of known misinformation constitutes tactics endorsed of the harm caused. Officer Brendan Bork, while acting under the color of law, knowingly made false statements under oath during plaintiff's trial, including that the plaintiff failed to comply with orders to back up.
Now, see, here's where things get a little bit dicey, but I haven't had a chance to really think about it because I have other work to do. And he's suing the judge. But this sounds like suing them in their official capacity. So that gets a little bit dicey because he's suing them individually, he claims, but at the same time, he's relating to what they did in their official capacity. I put it on my channel in December of the Hibbert decision, which showed that a conviction for resisting arrest and obstruction, a local obstruction charge, carried with it a fine only, moderate fine. That was it. And yet Chille and his lawyers never presented it to Judge Zimmerman to back up the contention of the prosecutor that really no jail time was warranted. I still think that the judge, and I can't prove this, I still think the judge whacked him like she did because of his actions while he was being sentenced. 6 months, that would destroy anybody. And, as you know, I predicted that they would run the sentences together, but I never said anything about 6 months. I figured at best he would get, a few days, a week, and then maybe work it off with good time credits.
His fabricated account of the encounter served as the basis for a 6-month jail sentence, an outcome that deviated from every comparable obstruction case Judge Zimmerman had handled.
Now, you see, that was one of the best arguments he could have made for disparate sentencing. I would love to have seen that in his appellate brief. It wasn't even raised. He said previously that she always gave people basically no jail sentence for these convictions, consistent with that Nevada Supreme Court decision. So if she singled him out for 6 months because she didn't like the way he behaved in court, that would have been a great argument to put in the paper, in his papers, as opposed to just simply saying, the judge is biased. You really got to be careful when you call judges biased because they're entitled to an awful lot of discretion.
The fabrication of evidence and the delivery of false testimony violated the plaintiff's rights under the 5th and 14th Amendment to due process of law and resulted in direct harm, including wrongful incarceration, emotional trauma, and reputational loss.
These are all conclusory statements, by the way. Institutional tolerance can be a form of willfulness. It also could be a form of negligence. Again, I would not use a phrase like institutional tolerance.
Prayer for relief. This is the last section right here.
Always is.
Wherefore, plaintiff respectfully request.
You don't have to say respectfully request. I know that's an archaic term. It's just like when Orrin would say comes now. I come now. I don't like the way that sounds. And God forbid you misspell it. Also, it looks like a ransom note when you start putting capital words in the middle of a sentence. It's distracting. And there was a lot of overriding. You guys saw me go through those pleadings. Let's continue.
Wherefore, plaintiff respectfully requests that this court enter judgment in his favor against all defendants and award the following relief. Compensatory damages in the amount of $29 million, broken down as follows.
Okay, so we got $29 million, and he's going to give us a categorization, an itemization of it. So let's start here. Go ahead, Chille.
$700,000 in direct loss of income over a 14-month period.
Okay.
$8 million for emotional distress, psychological trauma, and loss of familiar companionship.
Okay.
$1 million for business disruption and customer abandonment.
Okay.
$5.3 million for loss of future potential earnings across digital platforms, live stream, and public engagements.
Okay.
$10 million for Fourth Amendment violations, unlawful incarceration, and deprivation of liberty. Monell damages in the amount of $20 million for Clark County's systemic failure to supervise, train, and correct constitutional violations by its judiciary, bailiffs, and prosecutors.
My calculator, and unless it's wrong, we're at $45 million. Scotty, were you the one responsible for adding all those elements? Scott, come on. You know how kids are such a disappointment. Sorry, Chille. Let's go back. I think all of this was under many modes of preparation. We started with preparation A, and we wound up with a successful version of preparation H. And on the whole, I think preparation H feels right.
You guys hit the subscribe button. Everybody hit the subscribe button. We're on our way to 1 million subs. Hit the subscribe button. Everybody, subscribe to the channel. Help me get to 1 million subscribers. We were stuck at 630,000 because I wasn't going live all the time, but now we're back. There'll be 30,000 people that, Gloria, it was good to see you. Bill Real Birds, it says, great job, Chille. You're really an example of a true American. Thank you, Bill. I appreciate that, man. Coming from you.
Now, remember what he said in his complaint, the continued degradation of his name and business and everything. But here's what he's saying is quite the opposite. He didn't say the past degradation, although that's not a word I would use. I mean, it's even a hard word to pronounce. I would just say loss of sales, loss of income attributed to. But anyway, here he said
our rights. It's all of our rights. If they can violate my First Amendment right to assemble in the courtroom, well, then they can certainly do it to you. Because you don't have a public profile where there's hundreds of thousands of people that come by your channel every day. And right now, there's like 500,000 people a day coming by this channel. Did you know that? The numbers right now on this channel, I think we were like 750,000, 800,000 people a day for the past week.
It's amazing.
It's been crazy. The people are really coming back by. I think because I'm back and you're back, and so we're back. And we don't stop. Maddie, good to.
All right, so he's essentially admitting once again that he is a public persona. He also did try to run for governor, didn't he? So that would get him into the public persona thing. So for defamation, you know, he's going to have a very difficult road to climb on that. Well, there you go. Once I look at the complaint, I'll have a better shot at understanding it. But get ready for the attack motions. They'll be coming fast and furious. You'll be seeing 12B6 and anti-slaps. I doubt anyone is going just to answer this case and just put it at issue and move it forward. It will be attacked. Some of the arguments that will be attacked on will be judicial immunity, immunity for doing an official duty that is allowed by law. Chille says that he has a way around all of that, because obviously that's something that has to be considered. Anti-slap city, absolutely. And man, those anti-slap fees can add up and be just devastating if you get this wrong. See y'all later.